County.
Are you Republican or Democrat?
Both. Started out Democrat, became a Republican. Vote for both.
That's relevant, I assume. Go ahead. Go ahead.
Taxes,
Move on.
Ms. Reeves, you know Robert Smith?
I do.
How is it that you know him?
Robert's mother, Lou Alice Smith, taught me English at Waynesville High School in 1974. And she followed me through the years of my career and was proud of me. I was a student, I did well. And she would call and come by and call me from time to time. And I met Robert through her and watched him grow up. So I've known him that way. And of course, as an attorney, I've known him too.
Have you had dealings with him back when he was a defense attorney, or dealings with him when he was elected district attorney, or both?
Robert and I, of course, practiced in this area together, but I never had a case with him that I can recall. I've had a lot of cases, I may be wrong, but I don't remember a case with him in private practice.
Since he's been district attorney, have you been a defense attorney on occasion when he was district attorney?
Absolutely.
Have you formed an opinion as to whether or not he's an honest person?
I am.
What's your opinion?
That he's honest.
Has there been an occasion when Robert has asked you to serve as a special prosecutor?
Yes.
What is a special, like that, let me ask you this question. Have you ever gotten any authority from any judge to serve as a special prosecutor?
Yes, sir.
From what judge?
William Allen, I'm standing circuit judge.
And approximately when did Judge Gallup want you to serve as special prosecutor?
I'll tell you exactly. May 11, 2016.
Would you tell the jury whether or not there was more than one case, or was it just one case that you were going to serve as special prosecutor, or were there several cases?
No, sir. Mr. Smith had decided to create a public corruption section in his office to combat statewide and local corruption. He asked me to be a part of that as a special prosecutor, and I agreed to do that. And it involved a number of issues and cases that we were going to look into.
Would you tell the jury whether one of the issues that you discussed looking into with Robert Smith involved two assistant attorney generals, and whether or not they had threatened the witness or something like that?
It did.
And why was it? Do you recall why Robert was going to, or did you discuss with Robert assigning that particular case to you as special prosecutor?
We discussed it.
And do you remember why, what the reason was given as to why Robert wanted a special prosecutor for that case instead of himself?
He wanted some distance between himself and the people, the targets, and wanted to make sure that it was fairly done and looked into the right way.
About when did you have that discussion with him about you serving as special prosecutor in that particular case? About what did you say?
I don't know. Sometime around the time of my appointment or before or after, I don't remember. I'm sorry.
Do you remember whether or not you were going to present, or strike that, what were the plans regarding presenting the case regarding the two assistant attorney generals to the grand jury?
Well, the first thing is, I told Robert I need to seek the truth. A prosecutor first seeks the truth. But he doesn't prosecute, he seeks the truth first. So I said I'd look into it, and if circumstances justified, I would take action. If they didn't, I wouldn't. We never got to that point because this matter came up.
By this matter, what do you mean?
Well, we're here on the day. Mr. Smith was arrested the day we're going to talk more about it. So it ended those talks.
So, let me see if I understand. On the date Robert was arrested, as of that day, had y'all scheduled a meeting or agreed to meet concerning that particular case?
Yes, sir.
And to your knowledge, anything that kept y'all from meeting concerning that case other than Robert being arrested?
That's it. And that would be the reason why we didn't meet.
What was your understanding? Well, first of all, had you committed that you would take the case to the grand jury?
I committed that I would look into it and satisfy myself about the facts of it, the truth of it, and then make a decision. I didn't know enough about it to agree to present it yet.
All right. If, according to the way that you understood it, if the case was going to be presented at all to the grand jury, was it you who was going to present it, or was it Robert? What was your understanding?
Me.
And once again, why would you present it to the grand jury instead of Robert?
Well, it would put an objective individual in charge of it, because I didn't know anybody involved in it, wasn't involved in anything with it. Was just a special prosecutor doing my job, and if I determined there wasn't anything to it, I wasn't going to proceed. And if I did, I would.
Did you ever have an opportunity, you say you had a meeting scheduled with Robert, did you ever get into it enough to know about any of the alleged facts about it?
We had 2 meetings about it, but I recall not knowing enough about it to decide that indictments need to be handed down. I didn't know enough about it. I didn't know enough about it to present a case at that point. I had to look into it more. But I couldn't do it because he got arrested.
Now, let me ask you this, sir. If you had made the decision to present it, am I correct that jury either might or might not return an indictment when you present a case? Is that true? That's something about
It's up to the grand jury to return a true bill or not me and not the judge. It's their call to make.
All right, so in your understanding of your duties as a special prosecutor, even if a grand jury returns an indictment, if you determine for whatever reason that the evidence is insufficient or suspicious or that you cannot prove your case, in your opinion, would you then have the discretion to take a null process regarding that case?
I have a duty, not discretion.
What do you mean by that?
Well, a prosecutor's first job legally is to seek the truth, not just put people in jail. Find out the truth and find out whether constitutional safeguards are in place. If the truth shows no guilt, you shouldn't indict anybody. You shouldn't prosecute. Sometimes you indict and find the truth out later, you should drop it or proceed as the case may be.
What has been your experience as a practicing lawyer when a prosecutor, in your experience as a prosecutor, asks a circuit judge for a null process? What has been your experience as whether such a request or routine agreement?
That's relevant, Your Honor. I'm talking about other cases, talking about this case.
Overruled. You may cross examine.
I've practiced criminal law for 36 years. I've never had a circuit judge deny an null process order that I've been involved in, ever. Or justice court or city court judge, nobody's ever done it. If the prosecutor doesn't want to prosecute it, the judge doesn't get involved in it. And that would put the judge in the middle of it if you did.
When you say we put the judge in the middle of it, let me ask you this, sir. Does the judge have a duty to be impartial?
A legal duty and an ethical duty, both.
Is it any part of the judge's responsibility to evaluate the evidence in the case to determine whether or not the evidence is sufficient to proceed with the case?
No.
In your opinion, would that create a violation of the separation of powers of the Mississippi Constitution?
Exactly that, Your Honor.
Has he been tendered as an expert witness on separation of powers?
Not at all.
All right, just thank you.
Whose duty is it, as you understand the way law is practiced in Mississippi, whose duty is it to decide whether the evidence is sufficient to go forward with the case? Who has that?
The prosecutor. And in the federal system, when the prosecutor moves to
Objection. The federal system is not an issue here.
Just thank you.
okay, the prosecutor.
May I have this one?
Yeah, sir.
That's all right.
Cross examination is now.
And just a moment to look at the document. Reeves, you were referring to the document regarding the date you were born.
Yes, sir.
You have that document there, Reeves?
Yes, sir.
Might I have a look at it, sir?
Yes, sir.
Sir, this is not in any particular case that you were born, is that right?
That's correct.
You were just simply sworn in by Judge Gallo on May 11th of 2016.
That's right.
All right. Have you ever served as a special prosecutor before, sir?
When I was in law school, I was an intern with the DA in Warren County for 6 months. Since then, I've practiced defense law, not prosecutorial law, so no.
Okay. So as a special prosecutor, sir, do you know whether you would have had authority to even be in the grand jury?
I wouldn't, as an assistant DA,
Have you ever appeared in the grand jury as a special prosecutor, sir?
no.
Okay. And you indicated that you didn't know enough about the case at the last time you and Mr. Smith discussed it to know whether to present it to the grand jury or not.
That's correct.
So what you're telling this jury is you really don't have enough knowledge of the facts to say one way or the other whether charges against Sean Purin and Patrick Beasley and Judge Will had any legal merit or no legal merit.
I wasn't involved in Judge Will's case, ever.
You were not involved in that.
No. I don't
Mr. Purin and Beasley?
Those two, plus public corruption in general,
Okay,
campaign finance, this ending and so forth.
I see. And, sir, with regard to a null pros motion, I know you said they're routinely filed and they're routinely granted. Do you know what the law says specifically about a null pros?
Well, the judge has the right to review it and deny it, of course.
It says that a null pros will be granted with leave of court. Is that what the law says?
It does.
Which gives the court the authority to deny a null pros. Isn't that so?
That's right.
And the courts have, and may, on any occasion, deny a null pros motion. Isn't that true?
I've never seen a judge deny one. I'm sure that it's happened before. I mean, in my practice, I've never seen it.
Well, you've been a defense lawyer. How many null pros motions have you presented, sir?
Well, I don't present them, the DA does, but several through the years, at all levels, at justice court level, city court level, or whatever.
I see. How many cases do you have before Judge Will?
Several. Got some now.
And how many null pros have you been involved with in Judge Will?
I've had civil cases before him, no criminal that I know of.
So you don't know what Judge Will's practice is regarding null pros?
I sure don't.
All right. That's all I have, Your Honor.
Mr. Reeves, be finally excused.
Please, Your Honor.
Thank you, sir.
Yes, sir.
Charles Black.
Mr. Reeves.
Mr. Smith, check out, make sure he's here, Your Honor.
All right.
Charles Black.
What they call? Charles who? Charles who?
Where is the courtroom, you know? All right, would you come around and be sworn, please?
It's in black. That's in black and blue.
Raise your right hand. You swear firmly to tell the truth, the whole truth, and nothing but the truth, the rest of God. Yes, sir. Let me see.
Have you sworn correct examination?
Sir, what is your name?
Charles Brown,
Where do you live, Mr. Black?
4120 Sagamore Street, Jackson, Mississippi.
Do you know Robert Smith?
I have supported Smith through his campaign trail to re-election of district attorney.
You support him in the election?
Yes,
Do
sir.
you have any relationship with him other than that?
No, sir.
Do you know a man referred to as Too Sweet Henderson?
Yes, sir.
How is it that you know Mr. Henderson?
I know Mr. Henderson for 33 years.
Give an opinion of the honesty of Mr. Henderson.
75% liar and the truth ain't in him.
Did you have an occasion for Mr. Henderson to call you, I think it was approximately August, this past August, and relate to you threats, alleged threats to deal with?
Leading the witness.
Rephrase your question.
Did Mr. Henderson make a call to you which in any way regarded things that were happening to him with respect to the Attorney General's office?
Yes, sir. I received a 3-way call from Henderson, from Raymond, Henderson.
Who was the third person? You said it was a three-way call. Who was the other one?
His sister, Xavier McDonald.
All right, so do you remember the date when this was? Do you know when it was?
August if I'm not mistaken, August 4th, 5th, 6th.
Did you receive more than one call or just one call?
I received more than one call.
Okay. On 3 different dates?
Yes, sir.
What was the nature of the call?
Basically, Henderson was saying that if they had a statement that was did up, that if he would sign the statement, all charges would be exonerated and he would be free to go.
Did he tell you who the statement concerned?
No, I'm concerned about the Shuler.
God, he impeaches his testimony, that no pressure was put on him.
It's still hearsay, Your Honor.
So thank you for hearing.
Half on all date and time.
I'm sorry, sir.
Half on all date and time.
Did, while you were talking to Mr. Henderson, did he refer to Stanley Alexander?
Same exact
He-
hearsay.
None of it was truthful side, but the fact that Mr. Henderson did tell the truth in his own statement.
Your Honor, that's around the time they get hearsay, you know.
I asked you to plead your witness, Your Honor, except by calling somebody and said he said something different at a different time.
Give Mr. Henderson an opportunity to either admit or deny this phone conversation you're relating to.
I can't quote my words exactly, but I asked him whether or not he had been threatened in order to give his testimony. I promised him that.
Young man sustained, I don't remember a predicate question where he explicitly denied having a phone conversation on the 4th, 5th, 6th with this gentleman here, Mr. Brown. You can convince me that that's a specific question to ask and he denied it.
I can't say that I asked him a specific question. I simply asked him whether he'd been threatened and whether the Attorney General made any promises. That's what I asked him, and he denied that.
You still object?
Yes, proper deed, he's not been provided any discovery of all.
Your Honor, unfortunately, Mr. Henderson didn't testify until,
You had Mr. Brown on the witness list when we started the trial 4 weeks ago.
All right, so how much sustained is it?
Your Honor, I had a chance to make a record on this.
You heard outside the presence of your commission. Ladies and gentlemen, one more time, I'll get you to go to the jury room, I'll hopefully bring you back shortly.
So, Your Honor. All right. Mr. Brown, the jury's no longer in order, correct?
Yes, sir.
Would you tell me about what was said during the phone calls between you and Mr. Henderson regarding the Attorney General's office and regarding whether or not he had been promised in any way threatened anything by the Attorney General's office?
He said that he wouldn't sign the first statement, so they told him, the investigators told him, compliments of Stanley Alexander.
What was compliments of Stanley Alexander?
I enjoyed his stay at Victor Mason's Hotel with Sweets.
That's my opinion, Your Honor.
Well, Your Honor, two things I want to make clear. Mr. Wade has insisted throughout this trial and suggested that the state has not been forthcoming with him in discovery. This is reciprocal discovery that the law requires. When the defendant asks for discovery, the state gives discovery. The defendant is required to give reciprocal discovery, including any statements of any witness he intends to put on the stand in his case in chief, and a summary of the anticipated testimony. I have here Mr. Wade's third supplemental discovery to the state with regard to Charles Brown, who was a witness on the stand, and the only summary, the only knowledge he claims to have is, and I'll pass this up to the board, he knows that Smith is an honest person. If you look above there, Mr. Wade says he would only offer this regarding Robert Henderson if Robert Henderson is permitted to testify. Well, he's gone well beyond what he told the state in reciprocal discovery he was going to use this witness for. We've not been provided any phone conversation, any summary of a phone conversation, or anything else along those lines. He's already testified that he knows Smith to be an honest person, and we submit that even further testimony by this witness would be another discovery violation.
Now, may I reply to that just for a minute?
Well, before you do, I'm looking at Rule 613B. It says extrinsic evidence of a prior inconsistent statement by a witness is not admissible unless the witness is afforded an opportunity to explain or deny the same, and the opposite party is afforded an opportunity to interrogate him thereon or the interest of justice otherwise required. Not only are we dealing with the discovery violation issue, but I don't recall, Mr. Wade, you're asking Mr. Henderson specifically, did you on or about August 4th, 5th, or 6th, 2016, make the following statement to Mr. Charles Brown and give Mr. Henderson the opportunity to admit or deny having had such a conversation with Mr. Brown? My understanding of Rule 613B is to be able to put this witness on now to testify about what Henderson said back on August 4th, 5th, and 6th is not admissible unless you meet these standards here. So that's what I'm concerned about. There's no predicate laid to impeach Mr. Henderson with this witness's testimony.
Your Honor, the only thing I can say in response to what Your Honor, and Your Honor, I understand, Your Honor, understand the rules far better than I do, probably.
Well, on the court of appeals, there were times when I wondered.
But I felt like I couldn't quote the witness exactly what his exact words were. I mean, I didn't know the exact terminology. The exact phrase he used now, I couldn't remember that specifically, but I did ask him. I know that I asked him about whether the Attorney General made any promises or any threats, and he denied that he had, and he was adamant in saying he was simply up here to do justice or to tell the truth. And had no incentive or no reason whatsoever. I mean, even though, maybe the exact words couldn't come out, but it would be inconceivable that he certainly denied any threats were made against him or did any incentive to do anything other than tell the truth.
Well, yes, it's under Box v. State. Does the state want an opportunity to talk to this gentleman during the recess and then come back in and announce whether you're claiming some kind of unfair surprise and try to convince me to exclude his testimony? That's what I'm supposed to do. Well, I hadn't heard you ask for continuance.
I'm not asking for continuance. We're not asking for more time. We offer this, but the statement Mr. Wade is trying to get out now. You all will recall, he went to extreme lengths with Mr. Henderson about a conversation with Tony Davis and confronted him with that statement. And he brought Mr. Davis in here and put on what the court understood and allowed as proper impeachment. He didn't do that regarding any statements made to Charles Brown. And under 613 as well, I didn't reference that earlier, but I think that the evidence is not admissible.
That's my primary concern, more so than the discovery violation. It's an obvious discovery.
I didn't mention something about the discovery. I think we must have, I need to show the court in the transcript, but I am certain that when they gave notice, they filed, I forget what they called it, a notice of intent to call a witness.
They filed a notice of intent for a 404B witness, that is Mr. Henderson.
When they first showed me that document about Mr. Henderson, I inquired of Mr. Smith, what is this guy? What is he like and what is he about? And you did witness. told me that he did. When we were here having this hearing, I asked the court, and I'll try to find it in the transcript, I said, if the court allows this man to testify, do I have to give notice of impeachment? I'll have to find it in the transcript, and Your Honor, maybe Your Honor didn't understand the question, or I didn't understand the answer, but
Counsel, I didn't understand it was going to come up in this context. I think my comment was you can impeach him all you want. You cross it down and attempt to impeach him. That is Mr. Henderson.
Yes, sir, I'll look at the transcript. I have a copy of that transcript. I didn't have one of the first one, but I do have that transcript, and I can see exactly what it said. Your Honor's recollection may be better than that.
No, I don't remember you saying you're going to call a witness in your case in chief for the purpose of attempting to impeach Mr. Henderson. My interpretation of the discussion was you wanted to cross it down to Mr. Henderson and thereby impeach his testimony. I didn't know you were talking about a separate witness.
We miscommunicated, Your Honor.
Okay.
Because I was making a decision. I did not tell them about this witness in advance, because I was going to tell you what the trial thing was. I thought Mr. Smith was better off calling Mr. Henderson to put him on the stand, because I thought the jury had convinced he was a liar. And so I thought it would be much better to let him call him. And I thought, as trial strategy was, if they know that this guy's a liar in advance, they're going to put him on the stand, it's going to hurt my case. So I wanted them to put him on, because I told Mr. Smith, and I'll tell the court this, all this stuff that they're charging here is just a bunch of,
Well, 20 feet to the gate post, my inclination was to, under 404B, to prohibit Mr. Henderson from bringing all these other bribery things up, because it's...
What I told Mr. Smith was, the serious thing involved here is bribery. Mr. Smith said, I want my name cleared. Let's get this bribery stuff out now. I've got to get my name cleared. And I asked Mr. Smith, do you want me to object to Henderson testifying? And I told him, in my opinion, the jury's going to think he's a liar in any event, but you're running a risk, because I told Mr. Smith, I thought you would exclude it. Mr. Smith said, it ain't just this case. I want my name cleared. I don't want all this stuff in the declaring ledger about me being bribed all the time. I want my name cleared. I don't think the jury's going to believe him. We got witnesses, that he's a liar, so that's what I'm into.
Counsel, I don't think it's disrespectful, but this sounds like a tempest in a teapot to me. Do y'all strenuously object to this witness testifying about what he says and Mr. Henderson told him on the telephone? I mean,
I have no clue what he's going to say, Your Honor.
well, that's your question right now. You want to question this witness in the absence of the jury, you're free to do so on that subject.
What did Mr. Henderson tell you about a meeting with anybody that you know?
This was the 5th of August.
He told you it was this of August?
The question, sir, was what did Mr. Henderson tell you? That was the question.
Henderson said that if he had signed the statement that was already drawn up, that he would be exonerated of all charges.
I see. He told you this on August the 5th or 6th
It
of
was
this year. That's your recollection?
I talked to him the 4th, 5th, and 6th.
Do you know, sir, he had already been interviewed by the FBI about bribes he testified about?
No, sir, I did not.
I think it's improper impeachment. The court's inclined to let him go into it. We'll see to the court.
Mr. Brown, I tried to listen intently to what you just said. I didn't hear the word pressured, coerced, forced into signing a statement. What I heard you say is that Mr. Henderson said that if he would sign that statement prepared, that his case would go away.
Yes, sir.
He didn't use any phraseology about I was forced to sign it or I was intimidated into signing it. He just said if I sign it, my charges will go away.
Yes, sir.
All right, Mr.
Phone hung up. The phone was echoing, and I told him that
Say that again.
The phone was echoing, Your Honor, and I told the fourth and fifth party that was listening in that, I had them in prayer too, and at that time, all phones hung up.
Wade, do you want to ask a question about, I mean, I didn't hear any testimony about Henderson said he was pressured or threatened or forced to sign a statement.
Sir, he signed the statement, all charges will be, what did you say, we have the charges? Or what did
He said it'd be free to go. Basically, he said it'd be free to go. I just used another term of what he said, but he said that if he went ahead and signed the statement, that he'd be free to walk on all charges that they had pending against him.
Did he also say what would happen to him if he did not sign the statement?
He didn't exactly say, he just said that they told him, enjoy stay, because he told him that he didn't know anything about Robert Shuler Smith, to enjoy stay as far as being in Hinds County Detention Center, Compliments Stanley, Alexander.
Compliments Stanley Alexander?
Yes, sir.
Okay. Would you tell the jury whether or not you understood that? He said, if he gave the statement, what would happen to him according to Mr. Henderson? He signed the statement.
He did not go into detail about that.
Did he say that he would be let go?
He said that he would be let go, he'd be free to go.
And if he did not sign the statement, what would then happen?
Basically, it doesn't take a rocket science to read your minds. That he will be charged all the charges that they had against him, that the AG's office had against him.
What was in your other words, what was your understanding? What was your interpretation of what he said?
Basically, that he didn't sign the statement
Statement regarding what?
regarding that Smith was into some county corruptional activity.
That what would happen?
That he would be charged on all charges that they had pending against him.
And if he did sign the statement, what would happen?
He would be free to go.
I just feel like he was clear enough to him where he should have answered.
Well,
That he was threatened. I mean, if you sign a statement, you get out of jail, and you don't sign and stay in jail, then maybe that's correct.
Well, sir, the statement may be the gospel truth. As far as I know, and you know, I don't know.
Well, the question whether he was threatened to sign it, not whether the statement was or not.
But the implication is that only if he would sign a false statement against Mr. Smith would he be free.
All right, so let me ask you another question. Did he make any statements as to whether he knew anything incriminating about Mr. Smith?
He said he don't know anything on Robert Smith. Those are his exact words.
All right, anything else? It's my opinion that the rule 613B, that the requirements of that rule have not been met, so I'm going to sustain the conviction. It's hearsay. It's not, no proper foundation has been laid to allow this witness to attempt to impeach prior witness's testimony with a prior inconsistent statement of that witness. That's my rule. Y'all need a short break before we come back with the jury?
Yes, I did several witnesses.
All right, that'll be good. 10 minutes, we'll return.